Hi friends, in this video we are going to deal with the case summary of the latest Supreme Court judgment pronounced now in the area of criminal law, especially matters involving banning of two-finger test in rape cases. To know more about it, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled The State of Jharkhand versus Shailendra Kumar Roy alias Pandav Roy, pronounced on 31st October 2022, a FIR was registered against respondent based on the statement of the victim. Upon completion of the investigation, charge sheet was framed for offences under sections 307, 341, 376 and 448 of IPC. The death of the victim led to the submission of the supplementary charge sheet against respondent with reference to section 302 of IPC. After the trial, the Sessions Court convicted respondent of offences under section 302, 341, 376 and 448 of IPC. On appeal, the Jharkhand High Court set aside the judgment of Sessions Court and acquitted respondent. Being aggrieved, present appeal has been filed with issues posed for consideration, and they are whether the statement of the deceased is relevant under section 32(1) of Indian Evidence Act 1872 and whether the prosecution proved the charges against respondent beyond reasonable doubt. The Supreme Court has held that section 32 of the Evidence Act provides that in certain cases, statements by persons who cannot be called as witnesses are relevant. Dying declarations are made relevant under subclause 1 of section 32. In terms of section 32, statements of relevant facts are themselves relevant facts when they are made by a person who is dead, a person who cannot be found, a person who is incapable of giving evidence, or a person whose attendance cannot be procured without an amount of delay or expense. Class 1 indicates that in cases where the cause of a person's death comes into question, a statement made by that person is relevant when it relates to the cause of death or any of the circumstances of the transaction which resulted in death. In the present case, the statement satisfies the conditions laid down in subclass 1 of section 32 as it relates to both the cause of death as well as to the circumstances of the transaction which resulted in death. This is because the statement clearly described that the respondent poured kerosene on her and set her on fire. The post-mortem report concludes that the cause of death is due to the burn injuries sustained by the deceased. The statement of the deceased indicates that she sustained the burn injuries as a result of the respondent having poured kerosene on her and setting her on fire. In addition, the statement of the deceased discloses that the respondent raped her before setting her on fire, which is a description of the circumstances of the transaction which resulted in her death. The statement of the deceased therefore satisfies the conditions in section 32(1) of Evidence Act and is itself a relevant fact. It shall be considered to be a dying declaration. There is no rule to the effect that a dying declaration is inadmissible when it is recorded by a police officer instead of a magistrate. Although a dying declaration ought to ideally be recorded by a magistrate if possible, it cannot be said that dying declarations recorded by police are inadmissible for that reason alone. The issue of whether a dying declaration recorded by the police is admissible must be decided after considering the facts and circumstances of each case. In its judgment, the High Court incorrectly observed that in his cross-examination, PW6, the doctor, stated that he was examining another patient in the adjacent room when the victim's dying declaration was recorded. The record of the cross-examination indicates that the doctor stated that he was examining a patient on the adjacent table, not in the adjacent room, as erroneously stated by the High Court. The High Court mistakenly relied on this fact to hold that the victim's statement could not be treated as her dying declaration. Further, nothing on the record indicates that there was any enmity between the deceased and the respondent which would lead the deceased to narrate an untrue account of events and falsely implicate the respondent. Therefore, the dying declaration was made voluntarily and is true. The deceased was in a competent state of mind when she made a statement to PW11, the investigating officer. There is nothing on record which gives rise to reasonable doubt as to the respondent's guilt. The witnesses, including the family members of the deceased, being declared hostile is insufficient to cause doubt upon the prosecution's case. It was not the prosecution's case that the hostile witnesses were eyewitnesses to the crime. Rather, these witnesses' testimonies were relevant mainly to show that the deceased consistently stated that the respondent raped and murdered her to different persons. The absence of evidence which establishes the consistency of the dying declaration over a period of time is not fatal to the prosecution's case. Thus, the prosecution proved its case beyond reasonable doubt before the Sessions Court. The High Court ought not to have overturned the Sessions Court judgment. While this court does not ordinarily interfere with orders of acquittal passed by the High Courts, it may exercise its power to do complete justice and reverse orders of acquittal to avert a miscarriage of justice. This court therefore sets aside the High Court's decision and restores the Sessions Court judgment, convicting respondent of offences punishable under sections 302, 341, 376 and 448 of IPC, as well as its order sentencing the respondent to rigorous imprisonment for life for the offence punishable under section 302 of IPC and rigorous imprisonment for 10 years for the offence punishable under section 376 of IPC. These sentences are to run concurrently. The parting remarks are that while examining the victim, the medical board conducted the two-finger test to determine whether she was habituated to sexual intercourse. This court has time and again deprecated the use of this regressive and invasive test in cases alleging rape and sexual assault. This so-called test has no scientific basis and neither proves nor disproves allegations of rape. It instead re-victimizes and re-traumatizes women who may have been sexually assaulted and is an affront to their dignity. The two-finger test or pre-vaginum test must not be conducted. In Lilu versus State of Haryana, which was reported in 2013-14 SSC 643, this court held that the two-finger test violates the right to privacy, integrity and dignity. Whether a woman is habituated to sexual intercourse or habitual to sexual intercourse is irrelevant for the purpose of determining whether the ingredients of section 375 of IPC are present in a particular case. The so-called test is based upon the incorrect assumption that a sexually active woman cannot be raped. A woman's sexual history is wholly immaterial while adjudicating whether the accused raped her. Further, the probative value of a woman's testimony does not depend upon her sexual history. It is patriarchal and sexist to suggest that a woman cannot be believed when she states that she was raped merely for the reason that she is sexually active. In terms of section 53A of the Indian Evidence Act, evidence of a victim's character or of her previous sexual experience with any person shall not be relevant to the issue of consent or the quality of consent in prosecutions of sexual offences. Any person who conducts the two-finger test or pre-vaginum examination in contravention of the directions of this court shall be guilty of misconduct.